transition over here. But since we basically have now 5 minutes, I'm just happy to answer any questions that people may have on the ruling and as it applies to the colleges and universities in Washington State.
Jesse, what summary can you give us with reference to this? If you could do that for us, I would really appreciate a summary of the ruling by the Supreme Court with reference to affirmative action.
Well, number one, thank you, Lau. Number one, do not be dismayed by the narrative that the Supreme Court is putting out, as well as the media, that affirmative action has been killed or affirmative action has been terminated. Affirmative action is alive and well. What they basically said is that instead of checking the box, in other words, of race, that the applicants for our colleges and universities are now going to need to use that essay, that personal statement, as their opportunity to not only tell their story, but to say who they are. And colleges and universities that WENA has been in touch with are immediately adjusting to that. And you may have even seen Sarah Lawrence University, the president, I should say, of Sarah Lawrence, who has changed the process to now invite students to not only comment about their experience where it concerns race, but also Sarah Lawrence is inviting them to include how the Supreme Court decision has affected their rights where it concerns race. And so that's number one. Number two, affirmative action is still alive and well when it comes to military, recruitment and all the military academies, from West Point all the way to the U.S. Naval Academy, Air Force Academy, all the academies. And number three, I have to sound an alarm, and this is the final point, and that is an organization known as America First Legal. That's AFL, America First Legal. They are a right-wing organization that proudly proclaims themselves as the legal defense for white people. They have sent letters to 200 medical schools, including ours, 200 law schools, including ours, across the country, threatening the deans and presidents of these universities that if they do not abide by this Supreme Court decision, they will be subject to a lawsuit. And so we are putting together a response to that obviously is going to require a long-term effort to fight the fight and keep the doors of opportunity open for the next generation.
Are there questions for, Jesse, can you just tell us what the acronym for your organization stands for?
Well, actually, it's Washington Equity Now Alliance, and the Tacoma Pierce County Collective is one of the original alliance members of WENA, and so we represent all of the organizations that have been in this fight for the last 3 years.
Yeah, thank you. I just wanted you to say what WNA stood for. Questions for Jessie Wineberry?
Dr. John? Yes, Jesse, thanks you for that. I have a question regarding a editorial in the Hill. I'm sure you've seen it, by Eduardo Peñalver, who's the president of Seattle University, and Kent Greenfield, professor of constitutional law at Boston College. They compared the two SCOTUS opinions, one saying that affirmative action was not constitutional, and the other saying that it was okay for a business to discriminate against LGBT people on the basis of their beliefs. And they're saying, okay, fine, let's go with the second opinion, that free speech is protected, and therefore for a private Jesuit university that has very strong religious beliefs, we're going to do affirmative action under the second ruling. That is our First Amendment right to respect our religious beliefs. My question is, that's all fine in writing. Do you think they will actually put that to the test and take that to the Supreme Court and say that on the basis of their religious freedom that they will impose, that they are free to use affirmative action in their admissions?
That's a good question, and I'm really excited. When I read the op-ed, I was excited to see that because it's an ingenious way to comply with the court and comply with the law. But first, let's be accurate. The Supreme Court has not said affirmative action is unconstitutional. What they have said, more threading the eye of the needle, is that the explicit use of race as a factor is a violation of the 14th Amendment's Equal Protection Clause. And so that's why affirmative action is still alive and well. And the good news in terms of what you're pointing out is that the First Amendment, for some reason, has a supreme priority with the Supreme Court. And I believe that's why they are saying that university students or applicants to universities can still say what they want in their essay and in their personal statement. I'm sure they wanted to take that away, but their law clerks probably warned them that's going to be a violation of the First Amendment freedom of speech rights. So that's the pathway we need to use for those students who are not applying to religious colleges and universities like Seattle University, Gonzaga, and other Catholic universities. But I can't wait for the Catholic and other religious universities to push that lever and to defend their right to use race in terms of diversity under the doctrines of their religious institutions. And I think the First Amendment is going to rule when that case finally makes its way to the High Court.
Thank you. You're an optimist.
Regina, is your hand still up from last time? I'm sorry. Yes, it is. Okay, no problem, babe. Any other comments? Dr. Scott.
Thank you, Jessie, for that information. One of the things that we're looking at too in the Education Committee are things like adversity scores that Davis, University of California, Davis has put out, and the other elements that I'm interested in too have to do with sort of educational initiatives within the Black community that wouldn't necessarily have to talk about bringing in race as a factor, and things like the Rainier Scholars and their academic achievement efforts and so forth. In particular for the legal area, do you think that or have you looked at that question about adversity scores and things like that?
Absolutely. There's a number of ways we can go, not the court, obviously, that we can go based on the court's decision. Number one is adversity. I mean, adversity, I think, goes beyond race, because no matter who you are or what race you are, there's some adversity that you've had to overcome to get to the point where you are applying to college, or if you've already completed undergrad, you're applying to a graduate school. And I think a lot of universities and colleges are going to basically say adversity is the new race, if you will. Adversity is the new black or brown or red or yellow. The other way that we're advising colleges and universities to go is something that we've had in the past, and it worked in the past. It's socio and economically disadvantaged, so that there too it's not race, but most of the people of color, BIPOC communities are going to really be eligible for seats in college and financial aid and others, including the forthcoming challenges to business and contracting, when you use social and economically disadvantaged. That removes race, and it still allows millions of us across the country to advance and achieve our degrees and build our generational wealth.